What can we expect for employment-based immigration policies and processing in the Trump administration? Welcome to Live at Lunch. My name is Emily Sumner with Sumner Immigration Law, and today we are talking about having realistic and grounded expectations for what we can expect, what we can anticipate in the Trump 2.0 administration for employment-based immigration. So before we dive into some more detailed logistics here, I want to say, or just acknowledge, the anxiety that is in the air about everything relating to Trump and immigration. And it absolutely is well-founded anxiety. It is absolutely understandable if you, as an employer or employee or a family member, are anxious about the upcoming Trump administration and how that might impact immigration. We have been through this before, so we know somewhat what to expect, but there will be changes, of course, that we didn't see previously. So I want to acknowledge that anxiety, that fear, that worry that you may be feeling and say, we are feeling it too. But it is important, I find personally, that it's helpful to, of course, breathe deeply as often as we can and to get educated, to have a sense of what really is realistic about what may happen and what's not. I found in the past Trump administration, a lot of what we dealt with was anxiety, just this culture of fear and anxiety relating to Trump and immigration. That's not to say that there were not changes that were negatively impacted our clients' cases and potential clients' cases and other people's cases. For sure, it was a very, very tough environment, but a lot of it was fear, and fear isn't real as much as it can feel real. Absolutely, I know that in the moment. I absolutely get it. Anyway, I want you to know that we are here to support you and to help guide you through the next 4 years, whatever it is that's coming. So first, let's talk about trends during the past Trump administration, because what happened in the past may inform what is going to happen in the future. For employment-based immigration, we generally saw a tightening of policies. So definitely more requests for evidence with, especially with particular types of filings, such as H-1Bs, Ls, potentially an increase in perm audits, just tighter, a higher standard, more scrutiny. That does not mean that cases will not be approved. It does not mean that you cannot file for employees. It does mean we have to be really careful and strategic in preparing the filings. Of course, we always are, but can, definitely continue that and be mindful about what the administration may be looking for, and go into the filing with a realistic expectation that we may get a request for evidence that we would not have gotten perhaps during a different administration. And again, that doesn't mean it's the end of the world. It doesn't mean if you get a request for evidence that the case is automatically going to be denied, but it is probably going to take more work and effort than it has in previous administrations. Even though there may be more scrutiny, it might be kind of a higher standard. There are going to be 5 p.m. Friday afternoon announcements that happened during the Trump administration last time. They would issue memos on just policy changes or procedure changes. Nothing, they can't, an administration, a presidential administration can't change the law. They can't change the statute. And to change the regulations in general, they have to go through a specific procedure where there's a notice period, a comment period, that type of thing. There are certain narrow exceptions for that. But my point is that even if we do have more scrutiny, higher standards, even if things are harder, we still need foreign national talent here in the United States. That has not changed. That is not going to change. So we absolutely need that. And we are glad that the foreign national talent pool is here, and we are here to support you, here to support employers who are supporting those foreign national employees and prospective employees. So like I said, past administration, a tighter focus, higher scrutiny, more scrutiny. There may be certain cases, for example, there have been a lot of national interest waiver filings that have been done in the past several years, and they've been kind of, I'm going to say, marketed by some attorneys as kind of easy, and non-attorneys as easy to have approved. And that's not necessarily the case. It really hasn't ever necessarily been the case. but it may have been easier to have that type of case approved than before. And I think that's going to revert and not be as easy to have approved. The policy focus for employment-based immigration, we'll see what comes. I do anticipate that there could be more scrutiny with the H-1B visa program and other visa programs as well. It may be that wage levels change. It may be that there are changes in the way that cases are processed or adjudicated. There could be regulatory changes. It could be that the administration makes a change to eliminate the H-4 EAD. But we'll have to see what happens. All of this right now is speculative, so we can anticipate, what we expect might happen, but we can't predict 100% what's going to happen. So while changes, yes, absolutely are going to occur, there are going to be changes in policy procedure, unfortunately, that we don't find favorable for sure, but we've done this before and we're going to get through it again. So legal options remain. Remember that even if there are changes, for example, to the H-1B program, there is a letter, there's a visa for almost every letter of the alphabet. Admittedly, that sounds better than it actually is, because a lot of those, or all of those visa classifications, have specific requirements and purposes and durations and things like that. But there are other options in addition to the H-1B, and the H-1B is not going away. Even if changes are made to the H-1B program that are not necessarily favorable, there are always strategies and ways to address it. So we will absolutely get through this. So what are some actionable steps that we can take as employers of foreign national talent, as foreign national employees here in the United States, and their family members? Documentation and compliance is, of course, it's always been important. It's going to continue to be very important, making sure that you're staying apprised of the changes. So that means paying attention to changes that are happening with U.S. immigration. Our practice, Sumner Immigration Law, we send a monthly email newsletter the first Wednesday of every month at noon to anybody who subscribes. It's free. So we have updates that way. I'm very active on LinkedIn, posting changes there. And to the extent that there are changes that impact a large portion of our client base, we will send out breaking news alerts as well. So there are ways to stay informed and make sure that you're keeping your compliance documents updated. So that's things like public access files, for H-1Bs and other LCA-based filings like E3s and H-1B1s, making sure that your perm documentation is up to snuff, up to par. And that's what, we of course help employers with that as well. Making sure that you are not eliminating US workers, of course, who are qualified. Making sure that you have clean documentation of your attempts to contact potentially qualified workers. Making sure that you keep that audit file for the perm labor certification on file for as long as you need to. Making sure that your I-9 compliance is up to par. Preparing for labor market tests. I mentioned that just a minute ago with the perm labor certification process. That's part of the employment-based green card process for a lot of individuals, an option that a lot of individuals use. Again, it's not going away. The perm processing times are already a little long at 14 plus months. Hopefully that does not get worse, but even if it does, we will find a way to work through it. In terms of the testing the market, that's dictated by regulations, and it's unlikely that that will change. It is possible that that would change, but again, there usually has to be a comment period for that and an advance notice for that. But I think the key right now for employers is, again, making sure that you are really following the instructions that we, as your immigration lawyers, give to you for that testing the market process, that perm labor certification recruitment process. So when we say, please follow up with applicants within X period of time, or make sure that you have an email trail of your document, your communication, really making sure that you have that. That will be incredibly helpful in case the government does come back and ask about anything. We talked about alternative pathways other than the H-1B. I do think that the H-1B lottery is going to continue to be a thing, and that there will not be enough H's for everybody who's interested in applying for one. That is not anything that is unique to the Trump administration at all. It's been that way for years and years. I really think that's going to continue. So continuing to be flexible with the H-1B programs. meaning applying, registering your employees in the H-1B lottery when you can. So for example, if you have an employee who's eligible for STEM OPT, instead of waiting for that third year, if possible, go ahead and consider registering them in that first year. And then if they're not selected, they can try the second year. Also being kind of willing to think outside the box. There may be alternative visa options, like I talked about, that may work just as well as the H-1B. Staying informed, we talked about that a few minutes ago, making sure that you get your information from reputable sources. Even if you're getting your information from reputable sources, and by that, I mean like government websites, talk to your immigration attorney. That is what we are here for. And honestly, that's one of the things that I love most about my job is educating other people about what something really means and how it applies to them in particular. So for example, I just received an email from one of our clients, general counsel, with a question about a 60-day grace period. And he sent me a link from the USCIS website, great source, right? Because it's a government website. So it's not like you're taking this from like Reddit or something. But you still have to interpret that and apply exactly what the relevant regulations are to this particular situation. So my point is, just because you read something online, if you read something online, you think, oh my goodness, this is terrible, it's going to end my case or my employee's case or whatever it is, take a breath and take a minute to connect with your immigration attorney, because it may or may not be as drastic as you anticipate that it is. In addition, plan for renewals. We are starting H-1B extensions now earlier than we otherwise would have. It's still within the window for the extension, but we're starting those now so that we can get them in hopefully before there are changes. Same thing is applying. This video is about employment-based immigration, but the same is true for family-based filings. We have a flood of inquiries right now, people who are interested in starting sooner rather than later, so that hopefully their case is not impacted negatively by the Trump administration. Also look at green card options. We're also seeing an uptick in the number of inquiries about green cards, because that once you're able to get into that process, not always, but a lot of times, that provides some stability, some reassurance, knowing that you are, even if it's not immediate, because the green card process does take a while, but knowing that you've done everything that you can to just create this base of stability here in the United States can be very reassuring and helpful. So those are the practical tips that I have for you. Otherwise, I want you to know that we are here to support you. When I say you, I mean employers, employees, family members, individuals who are looking for support to navigate the increasingly complex US immigration system. I want to remind everyone that we, the Sumner Immigration Law Team, value foreign national talent and individuals here in the United States. We want you to be here. We want to support you with your journey here in the United States. Also, keep in mind, a prospective client earlier this morning was asking me what the timeline would be for changes. And we don't know. I remember that with the first Trump administration, there were some changes that happened very quickly, like the first week. I'm especially thinking about the travel bans for nationals of certain countries. So there could be some changes that happen quickly. There are other changes that don't happen as quickly, either because they do have to go through the regulatory process, or it's just, there's a lot that the Trump administration wants to accomplish, so it may not be at the top of their list. In addition, we do have a court system that hopefully will keep things in check. I know that can be a political issue as well with the appointment of judges, especially at the Supreme Court level, but know that there are lots and lots of litigators, immigration litigators out there who are ready to go to court if and when it's appropriate. And then finally, keeping in mind that support is here. You are not going through this process alone. We are here as immigration law professionals to help you navigate this process, to help you understand exactly how these changes are potentially going to affect you, and to help you find a way to ultimately reach your goal, whether that is the way that you anticipated or not. So I hope that you have found this information helpful. If so, please share this video with a friend or colleague, and please join us next time for our Live at Lunch, which will be next Tuesday at noon. Until then, my name is Emily Sumner with Sumner Immigration Law, serving clients with family-based and employment-based immigration matters around the United States and around the world. Hang in there.